This video was constructed as a part of the SP402 Takes On project. The intent behind this video is to answer the question, should children be required to partake in the Pledge of Allegiance during school? We will discuss the case itself and the historical significance surrounding this landmark decision. But before we go any further, we should review the case and the facts themselves. The West Virginia State Board of Education adopted a resolution on January 9, 1942, ordering students and faculty alike to, quote, participate in the salute honoring the nation represented by the flag, provided, however, that refusal to salute the flag be regarded as an act of insubordination and should be dealt with accordingly, end quote. Marie and Gaithy Barnette were Jehovah's Witness students who, at the instruction of their father, were to abstain from participating in the Pledge of Allegiance. They were then expelled from school for their noncompliance. Due to the fact that the Barnettes won the suit in the U.S. District Courts, the case was appealed by the school district and ended up making it to the U.S. Supreme Court. In a 6-3 vote, the court overruled its decision in Minersville School District versus Gobetis, which stated that compelling public school children to salute the flag was unconstitutional. In the opinion written by Robert Jackson, the court found that the First Amendment cannot enforce a consensus of opinion on any topic, and national symbols such as the flag should not receive a level of deference that trumps constitutional protections. Justice Jackson stated, quote, if there are any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein.
Why was the Pledge of Allegiance so important during World War II? This question can be answered by analyzing the case from a historical perspective that encompasses several important issues that may have influenced the notoriety, facts, and decision of this case. First, we must examine the origination of the pledge itself. Since West Virginia v. Barnette revolves around a group of Jehovah's Witnesses children and the refusal to recite the pledge or salute the flag, it is crucial that we first understand the genesis of the pledge and the salute itself. Francis Bellamy was a distinguished minister who was ordained at the University of Rochester. He originally wrote the pledge as part of an 1892 Columbus Day ceremony, and his original version states, I pledge allegiance to my flag and the republic for which it stands, one nation, indivisible, with liberty and justice for all. Notice that a key phrase of the pledge we recite today is missing. It was actually more than 60 years before the phrase, under God, was added to the Pledge of Allegiance by President Eisenhower in 1954. During President Eisenhower's first term, a Catholic organization named the Knights of Columbus organized a lobbying campaign for Congress to add the phrase, under God, to the Pledge of Allegiance, and on June 14, 1954, President Eisenhower signed the bill into law. However, this was 12 years after the West Virginia v. Barnette case. If you remember, the whole case was about Jehovah's Witness students who refused to take part in the Pledge of Allegiance and the salute at their school, based on the claim that their religious beliefs did not permit them to do so. Thinking about the later addition of under God to the pledge, it is worth considering if the Jehovah's Witness children would still object to the pledge if the phrase under God was present at the time of the case. West Virginia v. Barnette occurred in 1942 and was decided in 1943. During both of these years, America was heavily involved in World War II. Given the scope and circumstances of the war, propaganda was used extensively by both sides for a variety of reasons. Propaganda could be used for anything from recruiting and inciting national pride and support to demoralizing the enemy. When Francis Bellamy created the Pledge of Allegiance, a salute was also enacted to accompany the pledge. This salute was to be military style, and when reciting the pledge, each person was to extend the right arm straight forward and pointing slightly upward, with their fingers pointing straight ahead or in the direction of the flag if present. This two-part pledge and salute combination becomes important when discussing the West Virginia v. Barnette case, since Bellamy's influence had the two parts going together. One of the reasons that the Jehovah's Witnesses gave for refusing to take part in the pledge is their strict adherence to their religion and thus Scripture, in particular Exodus 20:4 and 5, which essentially forbids them from paying tribute to graven images. They considered the American flag a graven image, and thus a salute is a direct violation of this verse. Similar to the later addition of the phrase under God to the Pledge of Allegiance, it is interesting to consider if the grounds for refusal might have been different if Francis Bellamy had not created a salute to specifically accompany the oral pledge. A significant problem occurred and was discovered that both Hitler and Mussolini, prominent enemies of the United States during World War II, were utilizing similar salutes. There was a national concern that the enemies would take pictures of American schoolchildren performing the original Bellamy salute and then crop out the American flag, thus giving the impression that they were supporting the Nazi regime. In response to this, on December 22, 1942, FDR signed in the Flag Code Act, which changed the actual method of salute to the right hand over the heart as we currently practice today. During this time of war, it was so important to promote symbols commonly connected to patriotism that President Roosevelt actually took the time to acknowledge the danger of a controversial flag salute and then sign in a new law federally changing it. Furthermore, the Flag Code Act removing the Bellamy salute and replacing it with the hand over heart salute was signed in 1942. It is interesting to note that the West Virginia versus Barnette case was decided by the Supreme Court in 1943, prompting the idea that since this law was newly established, a violation committed would have more severe consequences. This may explain why the case was propelled to the highest level of law, being the U.S. Supreme Court, since the change to the salute was still new and had not been in law long enough to produce any controversy.
The decision of this case was announced on June 14, 1943, which also happened to be National Flag Day. This observance was established by an act of Congress to commemorate the adoption of the flag of the United States on June 14, 1777, by the Second Continental Congress. This is ironic because on a day dedicated to honor a sacred national symbol, the Supreme Court ultimately decided that participation in the Pledge of Allegiance does not correlate to the level of one's patriotism.